Let me know if you can't hear me. My name's Andrea Bailey. I'm the Director of Court Services and on the CPD Committee of the Law Society. We're here today to hear a presentation by Tim Outerbridge, who is the Registrar of the BC Court of Appeal and, more importantly, a Deputy Registrar of the Yukon Court of Appeal. I'm also here with Joan Peddle, who is the Registrar of the Yukon Court of Appeal. So she works with us in Whitehorse, and Tim, of course, is based in British Columbia, where the bulk of his duties are performed. Prior to becoming the registrar in June 2014, Tim was legal counsel to the BC Court of Appeal and an associate lawyer and research director at Alexander Holborn, Bowden and Lang in Vancouver. He has a JD from the University of Alberta, an MA in English from the University of Toronto, and a BA in English from McGill. So we're going to run this where I will, if you have any questions for Tim as the presentation goes, please put them in the chat and I'm going to moderate. And so we'll be interrupting Tim as he goes along. So ask questions in a timely way and we'll ask them to him in a timely way. And with that, I will turn it over to Tim.
Sure. Thanks, Andrea. I appreciate it. Welcome, everybody. Thanks for the opportunity to talk a little bit about work in the Court of Appeal of Yukon. I'm happy to be here today and grateful to be able to share a little bit of knowledge and information about how this court works. Because it's an interesting court. It's one that I'm going to go through a little bit of background here, and I'm sure that there are a lot of people on the call here who understand all of this. But as somebody new to practice in the Yukon, when I first became a deputy, it took me a while to learn a couple of key things, including how the courts were established. Yukon Territory Act in 1898. Interestingly, 9 of the 21 provisions of that legislation establishing the original Yukon Territory involved the courts. And so the British Columbia Supreme Court was originally the Court of Appeal for decisions of the Territorial Court. And our court was, of course, created and became the appellate court in 1912. And appellate functions were then transferred to British Columbia Court of Appeal. And Yukon status as a territory was changed in 2003. And so, as a non-Yukoner, you generally, as I understand it, don't refer to Yukon as the Yukon in the same way as you would refer to British Columbia as the British Columbia. You simply call it Yukon. And the Court of Appeal is the Court of Appeal of Yukon, not for Yukon, which is a common mistake made by BC practitioners. The Court of Appeal for British Columbia, and I see that a fair bit. And then the Chief Justice, if you ever have to refer to the Chief Justice, it's not the Chief Justice of Yukon, it's the Chief Justice of the Court of Appeal of Yukon, and it's abbreviated the same way. So these are some minor things, just starting off, where people could become easily confused between practice in Yukon and practice in British Columbia, particularly if there are a few British Columbia lawyers joining us all today. Or lawyers from Alberta, where I practiced before I came from British Columbia. So justices of the court, the composition of the court is interesting. Before Chief Justice Bowman was appointed, the court used to sit divisions of judges exclusively from British Columbia. But when Chief Justice Bowman was appointed, and since then, we have always included a northern judge on a division. And there will always now be a judge from Yukon Supreme Court, the Nunavut Court of Justice, or the Northwest Territories Supreme Court on any division that sits. And that's, of course, for the reason that those judges have particular expertise in dealing with cases from the north. And of course, we compose those divisions in such a manner that a judge is not sitting in appeal of their decision or a decision of their colleagues. So we sit in Yukon twice a year in June and November. So those are the assize, but a recent practice directive, which I'll get into in a bit, allows the court to also sit outside of those particular sittings. The key being that the Yukon court sits always in Yukon. We don't sit as the Yukon Court of Appeal anymore in British Columbia. If necessary, we do sit virtually. And can sit virtually in between assize for matters that are of urgency. You need to have your appeal heard urgently in between the assize. You can direct some correspondence to the registrar, who can try and decide whether it's the sort of case that requires a division to travel up there, or whether we can bundle up with a couple of cases and get those cases heard. So,
Tim,
yeah.
just one comment. Someone's saying the sound isn't very clear, and it appears to be a function maybe of your mic. I can hear you.
Oh,
Okay, I don't know if other people are having the problem.
okay.
And also, yes, the slides are going to be made available after the presentation. They'll be emailed out.
Yeah, we'll make the slides available for sure. Sorry, I'm not sure it's my mic because I'm using one of the mics that's right here in front of my face. So I'm not, maybe just the connection. Unless anybody else is having trouble hearing me, let me know. So the statutory powers of the court are probably one of the first things that you need to consider when you're practicing in the Court of Appeal of Yukon. It's a bit of a maze to untangle the powers that the court has. So the founding principle, or the first place to look, is the Yukon Court of Appeal Act, Section 1, which says that the court possesses the same powers, jurisdiction, and authority in relation to matters arising in Yukon, possessed immediately before January 1, 1971, by the Court of Appeal for British Columbia in relation to matters arising in the sea. So what that means is you actually have to go back to the Court of Appeal Act in 1960, which was the last revision in British Columbia, and look basically to see if there have been any sections that have been repealed or changed between 1960 and 1971. And there really isn't much. So if you look at the Court of Appeal Act from 1960, that's basically, other than the powers enumerated in the Yukon Court of Appeal Act as it stands now, the basis for the court's powers and jurisdiction. And as we'll see, there are problems with that because the legislation in British Columbia provides for some powers, but not others. And in particular, it gives a lot of powers to divisions that would normally be exercised by a single judge. So you get into a situation where sometimes you want to do things and assume that it's something that a single judge can do when in fact a division needs to be impaneled to do it. And then there's this other provision in Section 1 that says that the court also has the jurisdiction in relation to whatever could be before the English Divisional Court as of January 1st, 1971. I have no idea what that is, and I've really actually never seen anybody go and figure that out. So nobody's ever come to the Court of Appeal that I can recall who has said that this power or that power, you should be able to exercise this power or that power because the English Divisional Court as of January 1st, 1971 could do it. So that's a bit of a something that, as far as I know, hasn't been investigated as the basis for the court's jurisdiction. But technically speaking, we can do anything that the English Divisional Court could do in January of 1971. So I suppose if you can't find the power in the Yukon Court of Appeal Act, you can't find it in the Court of Appeal Act for BC 1960, if you really want to do it, you could go and hunt down whatever the powers were before the English Divisional Court as of January 1st, 1971, and figure out whether or not the court has that power. So that's the starting point. It's not particularly clear. There is potential for a new Court of Appeal Act to be brought forward and to be passed as legislation in Yukon. We've been making that request for some time because it does create a lot of pitfalls. And I mean, if you're not trained as a lawyer, if you're representing yourself, you can imagine how difficult this is for somebody without legal training. So that's the statutory basis for the court's powers. And so when we get into single justice powers, you don't really have any mention of a single judge's powers in the current Yukon Act. But you've got to go back to the, and I call it the 1970 Act, but it's actually the 1960 Act in BC, but it's as it was just before 1971. And basically, this is the distinction between the powers of a single judge and a division. This is a strange provision, but what it means is that that when the court is sitting, a single judge of the Court of Appeal. Sorry, let me just make sure I got this straight because it's confusing. But basically, a single judge of the Court of Appeal may at any time during vacation make an interim order to prevent prejudice to the claims of any parties pending an appeal. So what this means when it talks about vacation, it means during a time when the division is not sitting. So if you want an order, you want an interim relief and the division is actually sitting, then you have to get that relief from the court, not from a single judge. So there's this strange provision that exists about whether or not you have to go before a single judge. or not, and it actually depends whether there's an assize or not. So if the court's sitting, you need to go to the court to get the relief. If the court's not sitting, then a single judge can exercise the power. That's the interim power to prevent prejudice. So Whitehorse City and Darragh is the main case on that. So when you're thinking about whether you want to appeal a decision of the lower court, there's a couple of key points, and these are points that are not necessarily common to Yukon, but are in relation to any appeal that's been brought. The first question is jurisdiction. Is the appeal one that the Court of Appeal could even hear? So one of the things that has not been flushed out yet in Yukon is appeals from directions and reasons. So obviously no appeal lies from the court's reasons. The appeal has to lie from the order. But there is a body of law in British Columbia that has been gently tested in Yukon in a case called Dixon and Boontit. But that the principle is that if a trial judge gives a mid-trial evidentiary ruling, for example, that that ruling does not constitute an order, constitutes a direction. It's not something that can necessarily be appealed to the court. And the principle there is that in most situations, if you can wait to appeal a direction or an interlocutory decision of the trial judge, you should. You should wait until the final order of the court so that you can appeal everything at the same time. The aim of that case and the aim of the other cases in British Columbia are that you want to try and avoid litigation slices. And as a result, you want to bring your appeal when you got everything that you want to appeal done. And that's usually at the conclusion of the trial. So do be careful about trying to appeal mid-trial evidentiary rulings or other mid-trial rulings unless you have to. So leave to appeal is very different in Yukon. In Yukon, there's no standalone leave requirement. So in our court, in British Columbia court, there's a list of limited appeal orders that require leave to appeal. In Yukon, there's no such list. So most appeals go by right, and that would be unless the statute that you're appealing under is not the Yukon Court of Appeal Act and prescribes an independent requirement that you seek leave to appeal. Of course, the question of whether the appeal is arguable, I'm going to get into that in a moment, is important. If you're a respondent, one of the things that you might want to think about is preliminary objections. So if the appeal does lack jurisdiction in your mind, if there's a problem with the document that's been filed, you can always file a preliminary objection and seek to quash the appeal on the basis the court lacks jurisdiction or any other basis, including the appeal is an abusive process because it's so unmeritorious, constituting abuse. So that is the method as a respondent for you to dispose of appeals that you feel are reach a very high threshold of lacking merit, or are appeals where you feel the court lacks jurisdiction to hear the appeal. So we'll just talk about standards of review. I'm sure those that have practiced in the courts of appeal before know all about this, but I think for those that are newer to appellate practice, because this is an appeals basics seminar, I'll go through standards of review a little bit. So if you're dealing with facts, factual inferences, or errors of mixed fact and law, you're dealing with palpable and overriding error as the standard. And so you need to be able to ask yourself questions like questions I've asked here, which are, is the error, factual error, really obvious? Is it easily seen? Has the trial judge ignored conclusive or relevant evidence, evidence that's central to the conclusions? Have they misunderstood the evidence? They draw erroneous conclusions from the evidence. Most importantly, and I have put this here, is did the mistake have an effect on the outcome of the decision? Oftentimes, people will point to a palpable and overriding error or factual error, and they'll say this is really wrong. But the court will say, well, did it actually impact the reasoning of the judge at the end of the day? So you've got to look at that question as well. So the question becomes really, is in totality, is there a body of evidence that properly, judicially, and reasonably supports the conclusion? And you've got to be able to really put your finger on the error. It's got to be something that leaps off the page if you're going to hang your hat on a factual error. If you're talking about discretionary decisions, I found
Tim, one quick question going back to your last slide. You were talking about the leave to appeal, and we just had a question about whether there's any statutory requirements for leave to appeal. And Joan and I are aware of the Public Utilities Act here, but are you aware of other Yukon statutes that have a leave requirement?
No, not off the top of my head. I tend to keep a list of statutes where leave is required. And I have a BC list. Unfortunately, I don't have a Yukon list. It would be interesting for somebody to compile a list of statutes that or where leave is required. And maybe somebody could, Andrew, we could look at that at some point and put that out because it would be useful, I think, for those bringing appeals to have a list of statutes where leave is required. Of course, it's got to be updated, if new things are added. But we do have a similar list of that. So I'm not aware of the statutes that prescribe leave, but if you're bringing an appeal, just want to check the statutes that would ground your appeal if it's not the Yukon Court of Appeal Act, and make sure that you check judicial reviews of any sort. For example, usually there's some form of leave requirement potentially there, even if the first step is the Supreme Court. Sometimes the statute will prescribe a leave requirement going up to the court. So the lesson is to go back and just look at the statutes that are engaged and just make sure that there's no section on appeals that deals with a leave requirement, because you'll often see it, particularly in judicial. So back to discretionary decisions. So I found this description of discretionary decisions to be really helpful. It's from the 2016 case. An issue is discretionary if being governed by no rule of law, its resolution depends on the individual judge's assessment within such boundaries as have been laid down what is fair and just to do. People often confuse discretionary decisions with findings of fact. Really what it means is once the judge is armed with the necessary factual findings and law, and they have to make a judgment call one way or the other, usually on a more minor point, it can be considered an exercise of discretion. Exercises of discretion are also owed particular deference, and they're really only reversible when the court has misdirected itself or come to a decision that's so clearly wrong that it amounts to an injustice. So you're looking at a similarly high standard as you would for palpable and overriding error. And then legal questions, including extricable ones. So legal questions are ones that touch on the scope, effect, and application of a rule of law. So there is often a Herculean struggle for appellate counsel to try and construct their argument as one that engages a question of law as opposed to a question of fact, or most importantly, a question of mixed fact and law. But if you have, I will say this, if you have something that ends up being a error of mixed fact and law, don't try and construe it as an error of pure law. This is often attempted, or can see it, and it's nobody's advantage. But if you have an independent, separate legal finding where you want to challenge that, the standard, of course, is correctness. The understanding there is that the Court of Appeal is in a position where it can apply a legal question as well as a trial court can. And just be wary of the area of contractual interpretation. There's a line of authority arising from the Supreme Court of Canada in SATFA, talks about contracts as a particularly difficult and evolving area of appellate review. So let's just talk a bit about preliminary steps in our court. So filings and hearings in Yukon appeals is the practice directive that I was alluding to earlier in my talk. That practice directive states that basically everything that you file in the Court of Appeal needs to be filed in Whitehorse. Occasionally, if all counsel are located in Vancouver, we may hear interlocutory applications, stays and such here in British Columbia, in which case those materials can be filed in Vancouver. But everything else has to be filed in Yukon. The appeal needs to be filed unless the statute giving rise to the appeal is not the Court of Appeal Act. The 30-day timeline is the timeline for pronouncement of the judgment. When we say pronouncement, we mean the date the judgment was stated in court, not the date that the order was entered. I think that's the distinction. I think, if I'm correct, in Alberta, the date runs from the date of entry of the order, whereas British Columbia runs from pronouncement. So I think that the practice may differ in courts of appeal across the country, so just be aware that it's pronouncement, not entry of the order. If you have a problem with the way that the appeal has been filed, if leave is required, or if the document is unreadable or deficient, just make sure that you correct your notice of appeal early, because there's a point at which you can't amend it, and I believe it's after the fact are ready to be filed. Or if leave is required, it's usually before the leave application is brought. If you're an appellant, you have to furnish the court with proof of service, which usually is just a letter explaining why it is or how it is that you serve the notice of appeal. If you're a respondent, you want to be filing an appearance 10 days after being served. And then a couple of things that I always advise lawyers to do. First of all, make sure that you set a reminder for a year, because if an appeal exists for more than a year, it is automatically put on something called the inactive list, at which point you need to apply to the court to get it off that list and restart your appeal. It stays on the inactive list for 180 days, half a year, then it's administratively dismissed as abandoned. This is a mechanism the court uses to maintain control over its docket. Less important in Yukon, given the caseload is not as significant, but nonetheless, make sure you put a BF in your calendar for 365 days so you don't run into problems with getting on the inactive list. It's just a hassle to avoid. And the first step is always to try and get the lower court order entered. It takes time in the trial court to prepare the order, to get it settled if you must, and to get that order entered. And it's the first step in any appeal. Make sure you tend to that, because often takes, as I say, a lot of time. And if you get to the point where you want to bring interlocutory application, oftentimes the first question from the court is, what's the status of the order? And it's fine for some applications, even leave if the order isn't entered because you haven't been able to get it done. But you need to be able to provide the court an explanation, and the court needs to understand the efforts made to do that.
Tim, one question about whether the Yukon Court of Appeal has e-filing available, and Joan and I can answer that one.
Yeah, why don't you answer that question? That's
no.
That's right.
Yeah, the answer is no, we don't right now. But we are in the process of developing a new case management system, and so in that context, we're moving towards a digital registry as well as e-filing. So that project is expected to take 2 years, and Joan's very hard at work on pulling that together for the Court of Appeal. I don't know, Tim, do you have anything to add or?
No, Joan, I would ask you, do you take e-file documents, or not e-file, but email documents on occasion?
I do, but I also require the paper copies.
Okay. So I presume, Joan, that the practice is if it's an emergency or if something needs to get in quickly, that you'll take that document as an email document and then require the parties to file paper after the fact. Is that right?
No, everything comes by paper first.
Okay, all right.
But I think
Joan's my boss here, so I've got to make sure that I do right by Joan.
I think the reason for the email documents is because we are scanning everything into BC's digital system. So, if it just comes to us in paper, Joan has to scan and OCR everything and then put it up in your WebCat system.
That's true. Okay.
Yeah. All right.
So for chambers, all the school were a couple of common applications. So a lot of times in chambers, you may have to come in for an extension of time, or you may be closing an extension of time. I'll just say this about timelines in the Court of Appeal. Pay attention to them, because if you're late filing any document in the Court of Appeal, you've got to get into chambers and ask for an extension of time. One of the criteria that's considered by a judge on an extension of time is whether the appeal has merit. So particularly if you have an appeal where the merits are a bit questionable, you want to make sure you don't miss any deadlines, because if that application is opposed, there's a possibility that a single judge can dismiss the appeal as abandoned. It's one of the rare areas where a single judge of the court can get rid of an appeal. So the test is outlined there on the slide. Whether you had an intention to appeal, which is just have you made efforts to prosecute the appeal. How did you inform the respondents, or when were they informed? How much prejudice would there be to the respondents granting the extension? The merits test is quite low. You just have to show that the appeal is not doomed to fail. And then there's interest of justice test, and that's sort of a catch-all for the judge. If it seems like it's in the interest of justice that the appeal proceed, the extension will be granted. If the extension is denied, then the appeal is considered dismissed as abandoned, and the order entered will reflect that. So the denial of an extension of time for taking a step in the appeal will result in the conclusion of the appeal without a hearing. So deadlines in the Court of Appeal are pretty high stakes, particularly, as I say, if you've got an appeal that is a bit suspect. That said, between counsel, the court expects that respondents' counsel will not unreasonably oppose an extension of time. There's nothing worse as a chambers judge to go into chambers and see an appellant that's made a clerical mistake or a lawyer that's missed the deadline by a couple of days, faced with an opposed extension of time. Unless the appeal is completely useless, you should be consenting to those extensions and being reasonable in practice. And I'm happy to say that in most instances people are. And I would expect with a collegial bar like Yukon that we wouldn't have that problem that we sometimes do see. But you should be consenting to extensions where it is reasonable. Leave. So if there's a situation where you need leave to appeal, this is the process. You file a notice of application for leave to appeal 30 days from the date of the filing of the notice of appeal. And then a notice of motion for leave to appeal, which is 30 days from the date, 30 days from the date of the notice of application for leave to appeal. So your initiating document, if you're filing an appeal with leave, is different. It's a notice of application for leave to appeal, and that's filed, 30 days from the date that the order you want to appeal with leave was pronounced. Then 30 days from filing that, you have to file your notice of motion for leave to appeal and your motion book. And all that is served 10 days before the hearing of the application. Test for leave is summarized in a very, this is a BC Court of Appeal case, but it's been applied in Yukon. The question is the point of appeal significant to the practice? Is it significant to the action? And a different test for merit here, is it prima facie meritorious? And whether the appeal will hinder the progress of the actions. That particular criteria is whether in granting leave, this comes back to the earlier questions or point that I was making about interlocutory appeals that are brought mid-trial. Is the appeal going to hinder the progress of the action? And I see a lot of interlocutory appeals seated on this section. Bring an appeal of a ruling or a decision mid-trial. Again, first question, is it an order? Second question is, if it happens to require leave, which in Yukon it probably will not, it's no statute. But if you have something that requires leave, you've got to be careful that it doesn't hinder the progress of the action or the proceeding. It's a judicial.
Tim, another question about vexatious litigants, and it's whether they're required to seek leave or permission to appeal.
Sorry, vexatious litigants?
Yeah, just the framework.
So the vexatious litigant provision that exists, and it's a good question because I don't suspect that the 1960 Court of Appeal Act dealt with vexatious litigants. And I don't know if our current legislation, it does actually, because it was an amendment back in 2013 that deals with
and it's different than yours, I think, right, Tim? Like the Yukon vexatious provision is different than the BC one.
Yeah, it is. Sorry, I'd forgotten that the Yukon, the Act was amended, I think, in 2013 to add a vexatious litigant provision. And so there is that provision, and it's different than it is in BC. And in particular, it as I recall, it allows the Attorney General to appear by right. But if somebody is declared vexatious in the trial court, they are not automatically vexatious in the Court of Appeal. And there's a body of law in British Columbia that I'm not sure has been applied in Yukon that talks about that. It says that they have to establish that pattern of conduct in the Court of Appeal, but that their pattern of conduct in the trial court can't be taken into consideration, which means even if they don't have enough of an established pattern in the Court of Appeal, you can look to the pattern of conduct in the trial court and take that into account as a factor in considering vexatious litigant order in the Court of Appeal. So that's the body of law in British Columbia, and I suspect it would be similar in Yukon, unless the wording of the statute is different, and I don't think it is. But you don't automatically require leave to file an appeal if you're vexatious in the trial court, which I think is the answer to that question. Okay, stays of proceedings. A couple of differences in Yukon, at least in British Columbia. There is a limitation on when you can get stays in family law proceedings. There's no such limitation in Yukon. Section 13 of the Yukon Court of Appeal Act allows stays of proceedings to be brought either in the Court of Appeal or in the Supreme Court. So you can choose your forum. They can be brought along with a motion seeking leave to appeal, or they can be brought separately. Principle on stays is, generally speaking, a person that's won in the court below is entitled to the fruits of their judgment. stay is really only available where there's justice. The BC Milk Marketing Board case, which has been applied in Yukon, sets out the test, which is similar to the old RGR test: serious question tried, irreparable harm, non-convenience. And I've set the Yukon case that applies these principles on the slide here. So a stay of proceedings can be sought and obtained. Can be obtained both with respect to a stay of a trial court order, or if the matter is being appealed to the Supreme Court of Canada, you can get a stay of the Court of Appeals judgment pending the appeal to the no
Tim,
fee.
sorry, one more question, just a clarification about whether people are required to file both a notice of application and a notice of motion for an appeal that requires leave. And so I think the answer is yes, and I don't know if Joan has anything to add.
That is right. Yeah, so it's confusing because the initiating document on an appeal that requires leave is not called a notice of appeal. It's called a notice of application for leave to appeal. And sometimes people think, well, that's the notice of motion. It's not. That's just the initiating document. So the notice of motion, which brings the which commences the leave application, is filed 30 days following the notice of application. So it's a separate document. You file that with your motion book. Do I have that right, Joan? For sure.
That's correct. Yes.
Okay. So I was going to talk about no fee status. So this is an ability of a self-represented party usually to get a waiver of a court filing fee. Motions brought on the usual 2-day timeline. And those litigants will have to come into court and establish that they've got financial circumstances that where they can't pursue the appeal without undue hardship, and that they have an arguable appeal. And it's interesting, I pulled stats here in British Columbia, and I thought, well, people that are come in and have a no fee or indigent status application, I thought, if they really wanted to pursue their appeal, they would just ignore the court's judgment that said that the appeal may not be arguable and denying them the order. But in most instances, when the court makes an order that refuses no fee status, at least in British Columbia, the appeal doesn't proceed. Usually the self-represented party abandons it. So it's probably not all that relevant to lawyers practicing, but just be aware that these applications are sometimes taking place. And they do usually take place on notice to the other side, but it is possible also for self-represented parties to apply for and obtain these orders ex parte. So I'll come to security for costs. Security for costs is a real problem in Yukon, and it's one of the big pitfalls that we run into with the existence of the 1970 Act. Basically, you can't get it in Yukon, and if you do get it, somehow it's limited to $200. So the 1970 Act provides, again, security for costs to be posted by the appellant and an amount fixed by a judge part the court appealed from, not by a judge of the appeal court, and limits the amount posted to $200. That's because it's a 1970 Act, and $200 was a lot of money in 1970, but isn't much anymore. So the security for costs provision is effectively useless. So it cannot, unfortunately, be deployed as a tool, which it often is here at British Columbia, and we'll certainly fix this under the new regime. Get to it. It cannot be deployed as a tool to bring unmeritorious appeals to a swift conclusion if security cannot be posted. So that's an important thing to keep in mind in Yukon practices. You do not have that remedy or that tool in your toolbox, which is why I touched on the preliminary objection tool at the start of the presentation, because that's really the only remedy that you may have if you want to seek an early conclusion to an appeal. But we have BC deployed a number of tools in our new legislation that would manage vexatious or frivolous appeals at the front end, including a referral power to the division, both a referral power that can be exercised by my office, any judge, and we've enhanced the power of a party to bring challenges for jurisdiction front of a single judge in chambers to simplify the process. I would hope that some of those changes will be incorporated under the new Yukon legislation, but that's going to be, of course, for government to decide. I'll touch on remote appearances. It's very important in Yukon practice. We do have a practice directive called Chambers Applications by Telephone or Video Conference. It's a little bit outdated, but basically and practically speaking, post-COVID, you can do it in Chambers. So in Chambers, if you want to appear remotely, you're going to be able to do it. It's usually done by Zoom, and you just have to advise the registrar that you're intending on doing that. For appeals, it's a little bit different. If you want to appear remotely for an appeal, best practice is to just ask for permission as opposed to just advise the registrar, and the registrar will take that to the court. And again, in most situations, that permission is granted. And most particularly, of course, if we're hearing an appeal in Yukon remotely and counsel. Okay, so we've brought the appeal. We've either received an order granting leave to appeal or we filed a notice of appeal from that date. So from either the date that you filed a notice of appeal on the track where you don't need leave, or the date that a judge in Chambers granted you leave to appeal if you're on the leave track, 60 days from either of those dates, you have to file your appeal record. Your appeal record is basic. It's a document that just contains the key documents on the appeal, initiating documents. So that would be the most recent copies of the initiating documents in the court or tribunal below. So whatever started the process. If you're appealing from something from Chambers, it would be a notice of application or motion in the court below and the responding documents. Or if you're appealing from a trial, it would be the notice of civil claim or the statement of claim and the response. It's only those documents. You're not putting any evidence in here. It's just the documents that give rise to the appeal itself. Put the lower court reasons in, put the lower court order in, stick an envelope in there if you don't have a lower court order yet, you're trying to get it, and then you include your notice of appeal or your notice of application. Bundle that together in a book, and you send it into the registrar and serve it within that 60-day time. So that's, and then on the same timeline.
Tim, just a quick question about whether there's any legislative updates on the horizon to modernize the Yukon Court of Appeal procedure.
Good question. The answer is yes. There is. And I'm hopeful that following the election, that the updates to the Yukon Court of Appeal Act and the harmonization of the Yukon Court of Appeal rules with our rules here in BC will take place, because there are a number of places where that needs to happen. And it's an access to justice issue, of course, because as you can imagine, the points that I've made here are rather difficult for even me to get my head around. You know, if I haven't been working in Yukon for a while, you can imagine what it's like for somebody who's on their own trying to navigate the jurisdiction of court, trying to go back to an act from 1960. So the answer is yes. And, you know, we have, we obviously feel that it's a priority, but the government has other legislative priorities in Yukon, and so it'll be up to the government to decide whether they want to proceed with it. But we're certainly encouraging and have been encouraging that to take place for some time. Transcripts, same deadline as the appeal record. All you have to get is transcripts of oral testimony. So if it's something from Chambers and nobody testified, you don't need a transcript technically. If it's trial and parties gave testimony, you got to put all the testimony in, you got to order it unless the transcript is settled or the parties agree that it can be limited. So if only portions of the transcript are necessary, you can do one of two things. You can either agree amongst yourselves, appellate and respondent, that only part of the transcript is necessary and file it. Or if you can't agree, you can come before me, settle the transcript, or you can go before a judge if it's part of another application, and they can settle it and limit its size to what's required. There is no right to get a transcript, or no ability to have government pay for a transcript if the party can't afford it. I cited Sharpcore and Rostami, which is the case here. Similar authority in Yukon, where we often have people who are saying, "Well, transcript is so expensive, I can't afford it." But unfortunately, you've got to run the appeal that you can afford. The point, though, is if you're an appellant, you need to order the testimony that is required for the purposes of the appeal. I often have appellants that say, well, I'm ordering just this witness and this witness and this witness because those are the witnesses that I feel that I need for my factum. No, the proper question is actually what evidence is required for the appeal. So if there is evidence, testimony that is connected to the issues that are going to be on the appeal, that will be argued by either side, the transcript is required. And there is a line of authority that deals with fact-rich appeals or appeals that are complicated, and generally in those appeals, the court's going to be looking at requiring most of all transcript. Factums, so 30 days following the filing of the appeal record, and if necessary, the transcript, you file and there's actually an error here. It's not 30 days from the appeal record, it's 30 days from the appellant's factum. I'll fix that out before I send it out. 30 days from the filing of the appellant's factum, you file your 30 days from the date of the appeal record, you file your appellant's factum. I've got some factum writing tips in this paper. Chronologies should be short and to the point. Factum should be less than 30 pages. Don't put appendices in your factum unless they're enactments. There's no fresh evidence, and you file certificates of readiness right away with the time estimates. So after the appellant has filed their factum, you file something called a certificate of readiness, which shows that the appeal is ready to be scheduled for hearing. And you need to file that right away. And by that point, you really need to have the order entered if you haven't had it. I'm sorry, I'll just backtrack for a second. There is no error on the slide. It's 30 days from the date you file and serve the appeal record. That's when the appellant files their factum. Okay. Appeal books, those come in with the factums. So you file with your factum a copy of the appeal book, and this is where we get to the evidence. So within the appeal book, you include what is necessary to resolve the issues on the appeal. So not every exhibit from trial is necessary or is necessarily connected to the grounds of appeal that you want to put before a court. So you need to focus down the record and include only what's necessary. And they must have been materials before the judge below. So there's no evidence that goes in the appeal book that it was not before the judge. It's a separate process for adducing fresh or new evidence, and that's included in the rules. Get to that in a bit. But if you want to put fresh new evidence before the court, you have to satisfy the test in Palmer and Queen. And I'm going to get to that in a minute. There's a dispute about the contents of the record. Somebody's trying to put something in that they shouldn't, or there's a bunch of evidence that's not relevant to the appeal. You can come before the registrar and have those books settled, which means I can exclude or include evidence as necessary. There's transcript extracts in the Yukon Court of Appeal. You file those with your factum. We don't have a particular format for them, but they are the extracts of the transcript that you intend to rely upon at the appeal. Try and do a joint extract book if you can with your opponent, citing all the different extracts from the factums that are going to be relied upon. It's important to know, it's quite important actually, that you should put in what you feel is going to be required at the appeal, because often the court will not have a full transcript. It will just have the transcript extracts. So you may want to be a little bit liberal with the extracts. So fresh evidence, as I alluded to a few moments ago, process 30 days before the hearing of the appeal is to file an application under Rule 31, which talks about further evidence. File a motion and an affidavit. You generally don't put written argument about that fresh evidence in your factum. Keep it in the application that you're making for fresh evidence. So 30 days before the hearing of the appeal, you file your motion, affidavit, and written argument. Written argument contains your argument about the applicability of the fresh evidence. It can be hard because you've written a factum, and sometimes that fresh evidence is central to the argument that you've made in your factum. Generally speaking, if you can, and there are exceptions, if you can, try and keep the argument related to the fresh evidence separate in the written argument on the application. If you can't do it, just make sure that in your factum, you're clearly identifying what is fresh evidence and what is not, or otherwise your opponent's going to take issue with what you've done. The most recent case is Berendrecht, but effectively the same as Palmer, the old test, Palmer and the Queen. Could the evidence by due diligence have been adduced to trial? Is it relevant on a decisive issue? Is it credible enough that it's capable of belief? And would it have modified the results? There's a bit of a residual discretion for the court where the test is not strictly met. And the agreement between the parties that the fresh evidence should form part of the record is only a factor. It's not determinative of whether that fresh evidence will be accepted by the court. We used to talk about two categories, fresh and new evidence. You'll see cases talk about that. That's been overtaken by the ruling in Berendrecht. Really only talk about fresh evidence right now. We used to say that there was evidence that was fresh evidence, which is evidence that could have been but wasn't adduced at trial. And then we talked about new evidence, which was evidence that wasn't available at trial, but it had become available after the fact. Those categories, distinctions are gone. Basically now we just talk about fresh evidence as the same category. So when you're ready to set an appeal for hearing, and usually, like I say, that's when you file your certificate of readiness, you phone the court registrar, find a time. A half day is the default for an appeal from chambers. A day is the default for trial. If you want a longer period of time than that, usually the court will look at that question and decide on filing of the factums whether more than a day is sufficient. So make sure that if you're requesting more than a day of court time, that you're prepared to justify the request. Usually what will happen is Registrar Appellate will ask for some submissions on that potentially, or will refer the matter, if she's not comfortable deciding it, to somebody here to consider whether the appeal requires more than a day of time. Or if there's a dispute. Sometimes counsel can't agree. Sometimes we'll resolve those disputes as well. And as I mentioned earlier, the appeals are always now held in Whitehorse, whether they're done virtually or in person, whether they're done at the two assize or outside those assize. Video conferencing and broadcasting. Now, Andrew, you can interrupt me here if you need to, but we're broadcasting most of our appeals. If there is an issue with the broadcast, so if you've got, for instance, a highly sensitive set of commercial documents that are going to be adduced at the hearing, a sexual assault trial for a criminal practitioner, obviously there are certain appeals that are not amenable to being broadcast, and the court will give a party an opportunity to object to the broadcast and consider its appropriateness. The bar is quite high. We've certainly done appeals where we've broadcasted appeals where there are publication bans, with the understanding that counsel will be very careful about who they refer to and how they refer to witnesses at the appeal. So, there is not I'm not comfortable being on a broadcast ground for not broadcasting an appeal. So if the appeal is going to be broadcast, I assume that the registrar will let the parties know and give them an opportunity to object. Is that right, Joan? Do I have that right?
That's correct.
Yeah, and just to say too, if you're looking for the link to an appeal, it's attached to the docket. So Joan posted on the court's website with the Court of Appeal docket, the link's available there. And we follow the same guidance as the BC Court of Appeal in terms of what gets broadcast. And we do use a program like this, so parties can't interrupt and stuff. It's like a webinar format.
Yeah, I think this is another suggestion, and that is that BC also broadcasts all of its appeals. So I would really recommend that if you're new to a Court of Appeal practice, or even if you're not, and you haven't been in the court for a while, it's worthwhile, even if you're just tapping away on something else, to just pull up a broadcast and watch an appeal. You can get a feeling for the bench, you can get a feeling for what's happening, and you can understand sort of how the process unfolds. And you can do that by either clicking a link on the docket in Yukon or doing it in British Columbia. Every appeal, except for some highly sensitive appeals, are broadcast in BC. And we do on occasion get quite a number of people tuning in to watch, so you're welcome to come and watch our proceedings anytime. Books of authority. So these are the books that contain all the cases you've relied on. Just get a clear index there. File them 30 days before an appeal. Reference the page and paragraph where you're citing the authority. Again, court always loves joint books. So if you're doing books of authority, what you can do is file a joint book of authorities, and that then would be filed on the last date of the factums, the last reply factum that's filed. Put your joint book together and file that, and it is much better for the court. I can tell you that if you don't do it, and you've got two books of authority, and there's the same case in both books, inevitably what will happen is a judge will mark up one of the authorities, and the next counsel will take them to the same authority in their book, and the judge will be fishing around trying to find the notes that they made on the original case. So it's the same thing when you're presenting evidence to the Court of Appeal. If you have duplication between the two appeal books, it's not helpful at all, because the court will become confused, because they'll start seeing the same exhibit in two different places. And it just becomes a pain when you're writing reasons, because you're trying to find, the copy of the exhibit that you've written your notes on. So really, if you're doing separate appeal books, avoid duplication in them. If you're doing joint books of authority, it's always best when the appellant hands up a joint book, and you've got even a joint or joint condensed book. It's just perfect, and the court appreciates it so much, because it just makes for less moving of things around, and you get more undivided attention from the judges. So the order, the forms are there. You can include a term for costs. The Yukon Court of Appeal is silent on the question of costs, but if you look at Section 30 of the 1970 BCCA Act, it states that costs shall follow the event unless otherwise ordered for good cause. This is a slightly different standard than in BC. It may mean that there's less wiggle room for somebody to request a reversal of the usual costs following the event. So there are circumstances where it may make sense for a party to come to the court and say, even though so-and-so was successful on the appeal, I don't think they should get their costs, either because of conduct or because of some special circumstances on the appeal. Obviously, public interest litigation, all those regular exceptions apply. So if there is a dispute about costs, and there should be fairly few, but if there is a dispute about costs, you can write to the registrar and say, look, we can't agree on costs. Can we do some submissions to the division on the question of costs? You'll notice that the court often doesn't say anything about costs and their reasons. And that is because the court presumes that the parties will enter an order in most situations where costs follow the event. And in fact, the form of order includes a term for costs in it. But if you don't think that should happen and you don't want to sign the order with that term, you can agree with your friend. You can get that sorted out by the court. And we just never have appearances on it. We just do it with written submissions. It usually takes about 2 weeks, and the court renders decisions on those subjects very quickly. So you can expect that, particularly if the case is going up to the Supreme Court of Canada, that we'll manage that efficiently. And then assessments. I don't do many of these in Yukon, just given the size of the docket. But if you're first of all, if you are seeking type of costs, that if you're looking for special costs or increased costs, you should say so in your factum so the court is aware of that. Generally speaking, if the court renders its judgment and you haven't addressed costs, special term of costs, if you want special costs or increased costs, you haven't stood up and said something at the appeal, it can be difficult to get that category of costs after the fact. Costs are assessed for the registrar, so I can conduct assessments. I have on occasion, default is always scale 1. Don't do a lot of assessments in Yukon, I suspect, because the default rate is $60 per unit. And just for comparison, we increased that in British Columbia to $110 when we amended the Act and rules. So if you go through an assessment in Yukon, you're looking at maybe $5,000–6,000 for an appeal on average, plus disbursements. So it's not the assessment process may not be worthwhile given those costs. but it's up to counsel. And of course, I can deal with the settlement of the order and costs simultaneously. So if there's a dispute about the terms of the order, which is not a dispute about entitlement to cost, because the court needs to resolve that, I can resolve it and come up with the proper wording for the order, file an application for that purpose. That's pretty much everything. We've got all the way through from starting the appeal all the way to costs. I'll take any other questions that anybody might have at this stage, but thanks for your time today, and I'm glad to be able to give this presentation.
So a question, Tim, if security for costs is capped at $200, is it clear that costs can exceed $200?
Yeah, costs can definitely exceed $200. Again, I come back to the point that security for costs can exceed $200. It's got to be fixed by the judge below. But yes, it's a very good question. Costs can certainly exceed $200, even though security for costs is only $200. And the tariff of costs provides for that. So an appeal will most certainly exceed that amount.
Okay, I'm not seeing any other questions. So if you have them, oh, yep, thank you, Tim. it says Mark Jackson.
Oh yeah, Mark, my old colleague from Alberta, good to see you.
Nice.
All right.
Yeah, thanks, Tim. That was really, really informative. And I have to say, every time you talk about this act, I think I just get more and more flummoxed and confused about where to look for what it says. But you really help us immensely as we try to work through it here.
One of the problems is that, it's not very intuitive whether you're looking at the act or the rules. Sometimes you got to look at both. So one of the things we'll really try and do, whether we bring in new legislation, the government brings in new legislation, is to try and harmonize it. So it's really clear that we've got procedure in the rules. I think that's substance of the act, right?
Yeah. Yeah. Joan, do you have anything to add, or?
No, I don't have anything to add.
Okay. Well, thank you all very much for coming along. If there are other questions that you think of, or other procedural quandaries in Yukon, never hesitate to email Registrar Petal, who will try and answer the question. And if she can't answer it, she'll send it to me.